An irrevocable trust cannot simply be undone once it is signed. An irrevocable trust is a trust that generally cannot be changed or canceled once it is created. This is different from a revocable living trust, which the person who made it can amend or revoke at any time. Under Florida law, a trust is assumed to be revocable unless the trust document specifically says otherwise. Florida Statute 736.0602 makes this the default rule for trusts created after July 1, 2007. Once a trust is made irrevocable, the person who created it gives up control over the assets placed inside it. Those assets are no longer legally treated as belonging to that person. This loss of control is intentional. It is often the reason people use an irrevocable trust in the first place. Because the assets are no longer owned by the person who created the trust, they are generally shielded from that person's future creditors. Florida law addresses this creditor protection directly in the trust code. Irrevocable trusts are commonly used for advanced planning goals. These include protecting assets for a family member with a disability, qualifying for long-term care benefits, or moving assets out of a taxable estate. Even though the word irrevocable suggests permanence, Florida law does provide limited ways to make changes. A trustee may be able to use a process called decanting to move assets into a new trust with updated terms. Florida courts can also modify an irrevocable trust in certain situations, and in some cases, the trustee and all beneficiaries can agree to changes together. These options exist, but they are narrow and often require specific legal steps. An irrevocable trust should never be created with the expectation that it can be easily changed later. An irrevocable trust trades flexibility for protection, and that trade-off should be made carefully.